Mr Gorton.
Thank you. My Lord, the most important thing for me is which clock are you going by?
I'm happy to go by that clock.
Well, that means I've got an extra minute if it's 2:30 to 2:30 cut off. Can I just indicate what I'm just going to address you on now so as to really speed this up? What I want to address you on is the function of the case manager and why we say properly analysed that doesn't command that it be the medical director. And there are a whole series of points under that. Then I want to deal expressly with 2.14, hopefully in a better way than I did with Lord Justice Singh before lunch. And then I want to deal with sweep up provisions in relation to the judge's decision, which is largely in my skelly, and then deal with the cross appeal or the respondent's notice. And to make these submissions work on time, so as to give Mr Mitchell at least 10 minutes to get to his feet, I will be referring to extensively the speaking note, but not going through the speaking note, if I may. So if I can just deal with the content of the case manager's role, and we say the first big indicator of that is the name. You're the case manager. You're not the person who's deciding on dismissal. You're not the person who is adjudicating on people's rights. What you're doing is you're managing a process. And to largely administrative role, albeit commencing with a number of interlocking obligations which are set out in 1.6 about when concerns arise. And you're acting then as the medical director, you're acting then in conjunction with a number of senior officers, and those roles overlap. But when you come down to being a case manager, you are in fact in a largely administrative role. Another point that we make in relation to this is that if it's implied, as the judge appeared to have picked up, if it's implied that a medical director therefore has got medical skills and a medical skills dealing with a case in respect of a consultant is essential, we say that's absolutely wrong. Because if you look at the facts of this case, this has got nothing to do with medical skill. This is all about what the doctor's knowledge was of concerns in relation to let be at the material time. So we say in those circumstances, medical skill is not required. And if you needed to buttress that point, you've got it in relation to those below consultant level, because they have the benefit only of a senior manager, not a senior medic. So it doesn't make sense that this role title of being a medical director carries so much weight. The third point I want to make is that when medical interventions, in other words, when specialist knowledge is required, in fact, if you look at the procedure, that's a matter which falls on the case investigator. And our point on that is that it's the case investigator who carries all the load, or most of the load here. And can I take the court to the position in relation to the case investigator's role in the speaking note at paragraph 13? And 13.1 makes the point you don't have to be medically qualified. And 13.2 are the circumstances in which there are clinical matters which require expert advice. And those two instances there fall on the case investigator. So the burden of medical investigation falls on the investigator, not on the manager, although the manager has to arrange on behalf of the case investigator the outside opinion in relation to professional conduct. And also, and that point I say is a significant one because the case investigator isn't mentioned under 1.6. So if 1.6 was, as it were, the Bible, the fundamental beginning and end of roles, it's rather surprising that the case investigator is not identified in 1.6 in terms of its role, his or her role. And if this point needed, this is my an additional point, if this point needs any further emphasis, the idea that the knowledge of the skill of the medical director is somehow lost in the process is simply wrong. And I point that out, or we point that out in our speaking note. Can I take the court to it in relation to paragraph 19? So this is when the medical director is not acting as the case manager, and we say that there are at least 4 instances where the case manager, beg your pardon, where the medical director is actively involved. Aside from the very beginning when the concern comes in, which is we've already been through. So if we look at 19.5, he's got to be consulted along with the relevant persons, the CEO, the HR director, and the external body PPA, if informal resolution is appropriate. So the case manager consults the medical director. Likewise, in relation to the appointment of the case investigator, this is 19.6. Again, there's got to be consultation with the CEO and the HRD, but when the case investigator is being appointed, the medical director is involved. And I suggest this is fundamental. In 19.8, when the case investigator produces his or her report, and can I take the court to this, so Code Bundle 238, because this is important. My respectful submission. When the case investigator, who I say does all the heavy lifting, procures the expert evidence from outside, when that person comes to write their report, they are obliged to consult with the medical director and the HR director in relation to the report, the conclusions reached, and the course of action that they're proposing to take. And that is not only a matter of consultation, it's a matter of agreement with the medical director.
Sorry, where are you reading from?
Page 238,
Yes.
1.14, the case investigator, the penultimate bullet point. And also,
I'm afraid I forgot what OD means.
Organisation of development.
Organisation, it's the HRD.
I see, yes.
Splits into 2 in HR terms. Those who deal with HR and those who deal with organisation.
Don't worry, I've got it.
So, the idea that the most senior medic in the organisation, who's the MD, should retain a role is absolutely right, and they do. So the idea that they should only be compelled to be the case manager, we say it's quite wrong in those circumstances. And I took you to Mr Z's evidence this morning, and in particular in relation to why he was not the case manager in this case. And I say that's an exemplar, or that gives examples of why he may not want to be involved, why pastoral support might be necessary, why he might be involved in or within the curtilages of an investigation. There might be a conflict. The oversight role, that he's the RRO as well as the MD and therefore the line manager, that he might know things about the doctor which ought to be excluded from his mind for the purposes of being the medical director. But and that's his point, which is the necessity for robust overarching governance. So there are a whole series of reasons in my respectful submission and our submission as to why he should not be involved. And in particular, there's also the weight of responsibility. In other words, that's 24B, so that's page 195, supplementary bundle, paragraph 24B. The breadth of wider responsibilities that falls on his shoulders means that it's a burden too far, potentially. Doesn't mean he can't be, it means he can choose not to be by way of delegation.
Do we have any evidence as to how many consultants and clinical directors there are? I think there was evidence that he's responsible for 500 people altogether.
500, of which there will then be divisions, and
Yes,
there may be.
Do we know how many are above the line of being consultants?
I don't know, but I can find that.
We don't have the evidence of that.
We don't have the evidence of that. Or if we do, I'll be told I've not spotted it.
And we don't have any evidence as to, in practice, how many on average cases go through E27 each year in relation to consultants and clinical directors.
No, but Mr Z does talk about the E8.
Yes, but he doesn't say those are all the MHPS cases.
Yes, I think they are. You're right about that. And that could be, although I'm not giving evidence, the division here is that if you're I've got to get a move on. I don't want to spend too much time on that. And that directly feeds into 2 points of consideration. The first is evidence that he appended to his statement of other comparable or relevant medical directors. So that's page 187. Supplementary bundle 187, 188 and 189. Which, again, we say proves the flexibility. I can, I may, I do sometimes, I don't have to do it. I can't do it for these reasons. And specifically, the trust called evidence, which wasn't challenged, from PPA, Mr Wilkinson. You'll recall I took you to Mr Wilkinson's letter this morning in relation to the 6th of September. That's at page 162 of the supplementary bundle manual. And in particular, in terms of numbers and in terms of delegation, at consultant level, this might help my Lord Justice Nugee to a degree in relation to the numbers. Can I take your lordships to paragraph 6 through to 11? Invite your lordships to that, which shows, we say, how this is applied in practice.
Yes.
Linked to that is something of a jury point, but jury points sometimes are quite effective, which is that there's never been a challenge based on this case. When there have been, there is not a cottage industry, it's a minor industry in relation to MHPS challenges. And that's rather curious, we say. The answer is because everybody knows how this system works and how it should work and how it does work. But if it's a point that's been hiding in plain sight for 20 years and never been taken, which is a rather curious point. And indeed, as I said earlier, in relation to the Byrne case, the very defence organisation in that didn't take that point back then, because it isn't taken, as we say, is confirmed by the evidence in relation to PPA. Can I just then go on to deal with 2.14? I say immediately, this isn't an intentionally different clause. It all has to be read as a whole. My point about the exceptional nature of this is made by 2 points. First is the reason for introducing part 1 and 2, which is the end of the suspension culture. And the second, both in E27 and in MHPS, describe the circumstances in which you do exclude. In E27, it's the last resort, and the paragraph reference to that is page 241, 2.3. And in MHPS, it's in the most exceptional circumstances is the trigger, and that's core bundle 161 of paragraph 5. Critically, as well, 2.14 applies to everyone who is a medic. It describes it as a practitioner. So it doesn't draw distinctions between grades. Also, the power of delegation is expressly the power of delegation used in 1.6, which is the you can delegate this role to a senior manager to oversee the case. And so in those circumstances, we say 2.14 has got to be read as a whole. It is a surprise that in relation to 2.14, that you can take this step and appoint a case manager who is not the MD, if in fact that's not what the intention is. In other words, 1.6 must be read in light of 2.14. The two put together means that the power of delegation is much wider than is being contended in this case. And we say the only way that the claimant, the doctor, can get out of that is to argue an absurdity, which is that somehow this is a discrete function which calls for two different case managers. And that doesn't work. I give you the structure of the powers, but in relation to exclusion. Exclusion very often arises right at the beginning, because if a concern arises and it is a significant concern, then very often that power can be, the power of exclusion can be made immediately, and that doesn't have to be made by a case manager. But it's only once that person is excluded do you then get into the process whereby a case manager is appointed. And we deal with that in our speaking note. So in other words, dealing with my Lord Justice Newey's point a little bit earlier, when this arises isn't after a case manager, exclusion isn't after a case manager is actually appointed. It can arise immediately, as one would expect in those circumstances. And so finally we say in relation to this that the position in relation to delegation should be the ordinary position, which is the employer can act through people who are suitable. And if my learned friend is right, this has got to be a matter which also applies to every other officer that's identified in this case. So HRD can't delegate, can't act through a deputy. The CEO can't delegate, must act through, can't act through a deputy. The DBM can't, the designated board member, who's supposedly the referee to make sure nobody gets offside. And the chair can't do it because he or she has to delegate, has to appoint a designated board member. So the power of delegation, which is inherent in every employment relationship, is just lost. And I don't accept that you can't do that, but if you're going to do it, you've got to do it in the clearest way, which says it. And this doesn't. So for all those reasons, we say that the meaning argued by the doctor and accepted by the judge is wrong. I pick up in my Skelly about why certain aspects with respect to the judge, why we say he gets it wrong, and in particular the point in relation to the implied term. Your lordships will remember that we said, well, this can't be right, because you could have the medical director, if you're right, acting in his own cause, a judge in his own cause. He could be ill, he could be conflicted, whatever. And Mr Justice Sheldon's response, which in fact wasn't, if I recall correctly, I'm a learned friend was argument below, Mr Justice Sheldon's response is, well, you go through the implied term to do that. And we say immediately you run into the micromanagement, a legalistic argument, which is the medical director's role as being policed by way of a highly complex, if not nebulous, legal test of an implied term. And that's introducing a legalistic, formalistic complication which does not sit with these procedures. And so those are my submissions. We say, respectfully, the judge got it wrong. 1.6 doesn't have that effect. It's guidance. The appeal should be allowed. And in relation to the cross appeal, stroke respondent's notice, can I do no more than take you to my late file Skelly in that regard, which says, for all the reasons that it can't be sustained as a cross appeal, it shouldn't be entertained as a respondent's notice. It wasn't an argument. It wasn't a case that was being adjudicated below. So it wouldn't therefore be appealable, because it's not part of the order either express or not. And I've cited brace yourself. The relevant principle is in brace yourself. It doesn't work as an argument anyway, as I, in the exchange with Lord Justice Nugee earlier. All you're saying is, okay, that's our policy, we'll follow it. It doesn't establish any contractual rights. And so for all those reasons, those are my submissions.
Thank you very much. Mr Mitchell.
I'm great. We're dealing with the issue of costs. What I propose to do is take you to various citations, but I don't ask you to indulge turning to each page or each bundle out of the time I have. In terms of the order for costs, you'll find that in the core bundle at page 79. It's paragraphs 3 to 6 is part of the order, with the reasons that follow on the same page from paragraph 1. The judge addressed the issue on which the doctor was successful, first by reference to the list of issues, but he also noted that pleaded matters were not pursued, before then making the finding, and the words used are, these did not add substantially to the costs. And our position is that finding was made without relevant information. In other words, he made that finding without having before him any cost schedules or cost budget. You're taken to the list of issues, which is pregnant within this, because the doctor did not succeed in either all the pleaded issues, because they weren't all advanced, and they didn't succeed in all the issues that were pursued at trial. This appeal turns on how is success to be determined. Is success determined against the issues in the claim, the issues at trial, and where they're not aligned, as in the facts of this case, the issues in totality? There is a dispute between the parties as to whether issues were or were not prosecuted. We rely on the judge's finding in on page 79, paragraph 2, which directly finds that the matters were not proceeded with by reference to paragraph 10 of the Trust's submissions. And so in those circumstances, there's no appeal against that finding, and we say that's binding on you when considering this issue. We also, within our submissions, and you'll find those in the supplemental bundle at page 322 in particular, drew to the judge's attention that no cost schedules, cost budgets, or even indicative cost schedules had been adduced. In turning then to, there are some cases that were put before Mr Justice Sheldon. I don't propose to take you through all of them, but there's a useful summary insofar as if one is taken to the High Court judgment of Terror Court, which you'll find in the section 3 of the authorities bundle, within page 586, paragraph 79, and paragraph 12, cited on page 587, specifically invites that the extra costs associated with failed points should be considered. And on the fact of this case, the judge just didn't have any costs with which to consider. In terms of the case of Fleming, which is cited, my learned friends quote from that judgment in their submissions in the core bundle at page 313, paragraph 9. But when you look at the actual quotation in the authorities bundle at page 563, paragraph 35, whilst the judgment does say the party who has really won at trial is the issue, it states that is the starting point, not the end point. Your lordships will be probably more assisted by the judgment in Castor, and in light of that judgment, it's the judgment of Lord Justice Ricks, and I invite you to take particular attention to page 580 and paragraph 151, where Lord Justice Ricks noted in that case that the issue on which the successful party lost was not a separate head of claim. And that's precisely what you have on the facts before you here. The claimant prosecuted a number of claims within the claim form. They were synthesized and reduced in the list of issues, but they didn't succeed on all of them, and they were separate issues. I invite you, when you consider, as you will closely, the CPR 44, and in particular, I draw your attention to CPR 44 to subparagraph 4, and that's in the authorities bundle at page 735, and that expressly requires what the court will have regard to. A discrete issue is the issue as to whether we're advancing arguments against the cost orders of Mr Justice Garnham and Mr Justice Johnson. For your reference, those are at pages 206, paragraph 22, and 211, paragraph 18. But let me be clear. When those judges made orders of costs in the case was the pleaded case. And so when one is considering what costs should be awarded at the end, we don't accept that judgment that costs in the case should automatically result where a single issue, an important issue, succeeds. It results in all of the claimant's costs being capable of being awarded. So I turn then, in summary, to the conclusion that one draws from the issues. In terms of the pleaded claims, our position is set out in our skeleton, sorry, in our submissions to the judge, which you'll find on page 368, paragraph 94. The claimant only advanced 2 of the 8 pleaded claims. That's paragraph 82 you were taken to by my leader. In terms of the 6 issues that were in the list of issues your lordship now has at page 366, I just want to focus in on those slightly for a moment. The first issue is about the entire incorporation. Put aside that that was wrongly found as a concession, they did succeed on that. They did succeed on issue 2, but we submit that's a narrow issue of law, albeit one which has taken up a great deal of time today. However, issue 3, we say, is a practical consequence of issue 2 in particular. In terms of issue 4, we say that is substantive, and that's the issue where the doctor sought to challenge through the implied term the conduct of Miss Y in relation to the Thirlwell inquiry. Issue 5, we said wasn't pleaded, and that's found in paragraph 92 of the judgment. And issue 6, we say, in any event, is mechanical. So if one considers the judgment in Castor, first of all, this is not a judgment that is a fair result. It did not take into account relevant information. This isn't a case where the doctor was entirely successful, and there's an error in law by the judge not entering judgment for the trust on the matters abandoned by the doctor, and had judgment had been given, costs would necessarily follow the event. I believe I'm 15 seconds over.
You've done very well, Mr Mitchell. Thank you very much. Mr Sutton.
Please, Your Lordships. I'm going to endeavour to complete my submissions in an hour and a half, and then leave 10 minutes or so to my learned friend Mr Newey, who, like my friend Mr Mitchell, is going to address the costs issue.
Yeah.
We invite the court to find that the learned judge's approach in this case was correct, and that his reasoning was compelling in relation to the aptness of the relevant clause to be given contractual effect, which really lies at the core of this dispute in our submission. But because other issues have been raised, I'm going to deal with them, I hope, fairly concisely. The first is to do with the incorporation of the policy into the individual contract of the doctor in this case, and why we say that the provisions of the contract of employment are clear as a route to express contractual incorporation in a general sense. And we have always been clear that that does not mean that the policy in toto gains contractual effect. There is a further and critical phase of the analysis, which is that of aptness, looking at the individual provisions. Are they apt to be given contractual effect? And the courts have analysed that with reference to guidance, in particular that in Hussain of Andrew Smith J, but also other guidance as well. And yardsticks are offered indicia as they're described in that case, but those yardsticks include looking at the language of the provision. Is it a language that is aspirational, or does it have the flavour of guidance, or is it capable of being construed as a contractual term? And my Lord Justice Singh has picked up the reference to Keeley and to Lord Justice Dyson, who may have been Lord Dyson then, in relation to how that might be approached, a useful measure of testing that issue, and I'll come back to that in due course. So we'd like to address the issue of aptness, and in particular the further ground that is raised by the appellant in this case, which is whether or not the provision that is being focused upon, 1.6, has the effect that we contend for in terms of limiting the scope for delegation. Is it relevant to examine the practicability of that provision? And that's a significant part of the appellant's case, is how this works out in practice. And if that is a useful guide, what is the evidence that might be taken into account in testing that aspect of the case? I'll deal relatively shortly with the matters raised in the respondent's notice, not for lack of enthusiasm in relation to those matters, but because we put our primary case forward as a matter of express incorporation, because we regard the judge's analysis with great respect as being entirely sound. And then I will turn to my friend Miss Newey to pick up the issue of costs. Can I go first of all to the issue of incorporation? Of course, that takes us to the employment contract in this case. And that is to be found core bundle page 133. And the relevant provision, and I should say, and Mr. Gorton, I entirely agree with when he says that this is a standard form of contract across the NHS for consultants in England, introduced in around 2003 to coincide with the first phase of the MHPS introduction. And it's supported by a very detailed set of terms and conditions of service, which we don't need to take the court to, but those are referred to by reference at the start of the contract 133, and I think there's reference to it even in paragraph 1. But the provision we need to focus on is paragraph 17 on page 139. Our contention is that the language of that provision is crystal clear, and it has been interpreted in that way in a number of cases. In fact, there has been a consistent approach in seeing that as a secure route of incorporation, and I can give the court a variety of references. And it seemed to us that the case of Byrne was an example of that. There was no dispute in that case, which is usefully analogous for obvious reasons, that this did provide that route of incorporation. And we suggest that the case law, as I say, presents a consistent picture. It may be simplest to provide some references here for the case of Hamid, which is in divider 6 in the authorities bundle, excuse me. And that was a judgment of Mrs. Justice Swift, and she considered a case where at paragraph 59 of the judgment, authorities bundle page 79, she looked at terms and conditions of service for the new consultant's contract that hadn't been embodied into a similar contract to this, but the language is effectively the same. So we would refer the court to 59, 63, and 67. Those are paragraph references, 59, 63, and 67. And we note en passant in that case, the medical director, this doesn't feel like a jury point, performed the role of case manager. The case of Hussain, which I will come back to in relation to the indicia and the issue of aptness, again, we have the medical director, interim medical director in that case, appointed case manager. That's referred to in paragraph 44 of the judgment. Mr. Hussain's contract in that case is referenced at paragraph 144, appeal bundle 182. And his lordship in that case, Mr. Justice Andrew Smith, paragraph 166, with reference to the effect of clause 17 as a route to incorporation, and this is appeal bundle page 189, I would in any case conclude that the words of clause 17 are sufficiently clear to incorporate terms of the practitioner's disciplinary procedure, including the terms concerning conduct hearings that might lead to dismissal if that were introduced into the practitioner's disciplinary procedure by reference to the staff disciplinary procedure, which accurately describes the mechanism in this case. In other words, it's the disciplinary procedure for all staff in policy E5, with certain limited procedural modifications in the case of doctors. So we say once again, a useful comparator. The case of Chabra, divider 11, appeal bundle page 319. Once again, Dr. Broughton, the medical director acting as case manager. The issue of incorporation expressed as common ground in that case, paragraph 18, with the procedures summarised at paragraph 2. Case of Chakrabarti, divider 10, once again, the case manager performing, the medical director performing the role as case manager, that's to be seen at paragraph 7 and 14, and Mrs. Justice similar, as she then was, paragraph 107 through to 109, it's clear from the above, and was in any event common ground, that the MHPS framework as a whole was expressly incorporated into the Trust's contract of employment with its employees. And of course, her ladyship then examines the question of absence as a separate topic area. So we say those cases, if they don't, as it were, offer binding precedent, are illustrative of the position which we advance in this case, which is that the language of the contractual provision in the employment contract provides a clear basis for a route for incorporating by reference the provisions of the E27 policy.
Do you accept that there's no decision which is binding on this to that effect? But I think, do you accept that first of all?
There are a number of cases which have looked at identical or near identical wording and concluded, and I've given you the example of Hussein, where
the first instance judgment.
a first instance judgment, yes.
No binding authority on this court, is that right?
On this court, I agree, my lord.
But I think what you do, at least in passing, observe is that, for example, in Byrne, a very distinguished employment judge, Lord Justice Underhill,
Yes.
it didn't occur to him, as far as I can see from his judgment, that there would be any problem with that.
My lord, I didn't detect any
It
hesitancy.
wasn't. I know. It wasn't argued in that case.
Yeah.
As far as I can recall.
Yes,
Nevertheless, you make that observation.
I do, indeed. Can I stay a little bit longer with E27 on a slightly different point, but just to introduce the court to one or two of its specific provisions? And if we go to page 227 in the bundle, some points which will be apparent to the court, but I will labour them nonetheless. This is the start of the policy, and the court will see on 227 the process of approval via the Joint Local Negotiating Committee, and it is they that need, and that is a negotiating forum comprised of elected consultants, but also senior managers within the trust, often board members within the trust, who are engaged in the process of approving workplace policies and procedures. And in this case, we can see importantly at 232, paragraph 1, this is an agreement between the trust in that case and the local negotiating committee. And a little bit further down, outlining the employer's procedure for handling concerns about doctors' and dentists' conduct, performance and health. It implements the framework set out in maintaining high professional standards. And the point has already been noted that this is a negotiated, collectively negotiated procedure between stakeholders at national and at local level. And at national level, the Department of Health, the BMA, the dentist's equivalent professional body and or trade union body, and so forth. So it is collectively negotiated at both levels in order to ensure that the provisions contained in it strike a balance that is acceptable to both sides of the negotiating relationship. And at 1.2, MHPS must be followed in all cases involving medical staff until the investigation stage has been completed. A decision will then be made by the case manager on how to proceed. And we emphasize that that is a critical stage in the process. In fact, my Lord Justice Singh referred to Lord Justice Underhill in the Byrne case. Lord Justice Underhill pointed out how significant that decision can be for the doctor. And the decision here is the one that is taken as Appendix A, paragraph 120, page 239. And it is perhaps the most significant decision. And I emphasize the word decision because this involves an exercise of evaluation on how matters should be taken forward. And we say it is a matter of obviousness that the person who takes that role and their attributes in terms of their professional background, acumen, experience is likely to be of the highest importance. And that is when this framework agreement is formulated. And it is no answer for a trust in a given case to say, oh, well, we don't think this has much to do with clinical issues. The question is whether or not this agreement, when it was formulated, catered for circumstances where clinical issues were likely to be very much to the fore. And as the trial judge in this case noted, the gateway provision in this case involves issues involving patient concerns. In the precise language at 1.6, any potentially serious concerns, either those which have or may adversely affect patient care, must be registered with the chief executive. And that shows the context in which these procedures have been devised, that they are likely to have a clinical ingredient. And an important part of the structure of these provisions is that the decision on classification, is this a conduct matter? Is this a capability matter? Should this be referred to the GMC? Should we attempt remediation? That happens after the investigation has been completed and not before. The investigation provides the case manager with the material to make that assessment. And in making that assessment, their medical knowledge and experience is likely to be highly significant. We therefore describe it as an important procedural safeguard. Returning to the earlier provisions and to the collective ingredient in the way these provisions have been formulated, we see at paragraph 2 the purpose, and I'm back at page 233. The aim of this policy is to ensure that all conduct, performance, and health matters are recorded and dealt with in accordance with the framework set out in Maintaining High Professional Standards. Next paragraph. This document is designed to inform all staff of the Trust policy and procedures, their rights and responsibilities. So the notion that this is a framework which in some generalized sense provides guidance ignores the language of that sort of provision. It is a document which confers and enshrines important procedural protections and rights. And the same point emphasized in the next paragraph, to ensure that matters are dealt with in a fair and consistent manner. The further point I wanted to refer to before moving on from this part of the framework is the way in which changes and modifications to this policy are effected, because there is a mechanism provided for to achieve that. Over at clause 6 on page 234, 6.1, members of staff who have experience in applying this policy and the Employment Policy Review Group have been consulted in the review of the policy. It was approved by the Joint Local Negotiating Committee, ratified by the Workforce Committee, and then dropping down to 8.1, this policy can be amended at any time by joint agreement with accredited staff-side representatives or a change in legislation where there's any conflict or lack of clarity in the existing nationally agreed guidance will take precedence. That, of course, is a reference to the national MHPS framework. But finally, at clause 10, monitoring compliance with the effectiveness of policy, This policy will be subject to ongoing monitoring locally by line managers, and any deficiencies will be addressed through the divisional management teams. Where deficiencies are identified, an action plan will be coordinated by the author of the policy and agreed and overseen by the joint local negotiating committee. So a mechanism is put in place to evolve and develop this policy in circumstances where, to use that unattractive phrase, is not seen as fit for purpose. And that is a way in which its terms can be reviewed and revised. And we looked in the course of the trial at different trusts and how they have achieved that amendment to their local policy, with reference, for example, to the Morecambe Bay Trust. If we go to the supplemental bundle, supplementary bundle, and to page 8 through to 13, we can see the trust in that case again has the involvement of the local negotiating committee validating its procedure. You see that midway down page 8. And then at 1.1 on the next page, once again, it's expressed as an agreement between the trust in that case and the LNC, but they have modified the provision that we're concerned with in this case along the lines of 4121 on page 13. In other words, they have permitted a somewhat more flexible power of delegation, closely having regard to the need for clinical experience on the part of the case manager. But they have worked out, no doubt in consultation with the trust through the JNC, Joint Local Negotiating Forum, a modified procedure.
I'm not sure I fully followed your point, forgive me. Is the point you're making that this is an example of a different kind of wording?
Yes.
Or is it an example of where the wording was originally the same as what our trust had, but it was subsequently amended?
My lord, the latter, but in fairness, we don't know, we haven't charted that process of evolution. So it's a matter of inference. But what we can say is that it seems to provide a modified form of wording. Obviously, that's that trust and not ours, but in a way that might well have, if you like, met a practical concern that was presented to the JNC, that it's, in that trust view, desirable to have a looser power of delegation under its own local procedure. But of course, in order to meet the requirements of the consultant contract, the local procedure would need to be consistent with MHPS. And therefore, in any negotiating about loosening the ties, an eye would have to be kept on that essential contractual commitment. No doubt it was in that case. So, my lord, those are some observations in relation to incorporation and in relation to some features of the framework that we consider provide relevant context. And we regard the learned judge's conclusion, paragraph 94 of the bundle, core bundle, page 68, that this was the way by which the E27 policy was incorporated. We regard that as an entirely sound conclusion. We had understood that the matter was conceded or agreed. We thought matters had really boiled down to a point where aptness was the battleground. And if I've misunderstood my learned friend's stance on that, I apologise, but that was certainly what we understood the stance of the trust to be, and you've seen the list of issues, which appears to be an indication of where the trust was coming from, certainly so far as we saw it. Can I turn to the issue of aptness next, which, as we say, is, in our view, likely to be at the core of this dispute. The case of Alexander, Mr Justice Hobhouse, as he then was, introduces this language of aptness, and I don't need, I think, to take you back to that authority. It's in Divider 1, paragraphs 30 to 31. It's an off-cited passage, and I think it's been treated as a very useful touchstone in understanding how this sort of issue should be approached. In other words, what effect should be given to collectively agreed policies in terms of an individual employee's contract of employment. We also consider that the judgment of this court in Bristol City Council and Deadman is a very valuable authority.
And that one we should turn up or not?
If I can just invite you to note it, my lord, it's at tab 4. Lord Justice Morbick in that case once again provides very valuable guidance in terms of the approach to collectively negotiated policies. And I have in mind paragraph 12, I think, Ms Newbegan, perhaps paragraph 17, if my lords wish to go to that. But it's once again a passage that's referred to again and again in subsequent authorities. As 17 and 18, I'm grateful, providing useful guidance. So far as the issue of aptness is concerned, we go to paragraph 1.6, which of course is the critical provision in this case. And the indicia that have been pointed out by Mr Justice Andrew Smith, of course I'll come to, they provided a very important structure for the trial judge's analysis in this case, and rightly so, because they have been endorsed by this court, Lord Justice McComb in the Sparks case, which my learned friend has taken the court to. So it is guidance which has been authoritatively endorsed. But it's worth also noting the case of Byrne, where this court, and I have in mind Lord Justice Underhill, who gave the principal judgment in that case, although my lord made further observations, which I'll come to in relation to the operation of an implied term of fairness, which may be relevant to the cross appeal, which I'll deal with in due course. But Lord Justice Underhill was very much focused, perhaps as his first port of call, on the language of the provision. So, leaving aside other indicia, what do the words actually say? And we say that in this case, the language of the provision is clear, and that there is really no sensible way in which it can be suggested that this is ambiguous or admits of a variety of different meanings. It is clear. And we say that that is a very important starting point. And of course, Lord Newbega's guidance in the Arnold and Britton case very much endorses the primacy of the language used in interpreting contractual intention.
You can obviously find other authorities. I suspect the most useful really is the subsequent one of Wood and Capita, but anyway, yes.
Well, my lord, if I have the essential guidance right in our submission, then we'll certainly have regard to that in future cases. But we cite Lord Newbega's guidance.
Those who want strict interpretations always cite Arnold and Britton.
Well, we will go to the indicia because, of course, that provides a range of other considerations, and they were carefully weighed by Mr Justice Sheldon in this case. My lord, a significant consideration as well is the seniority of the individuals involved in the stages at section 1 of this process. And that is a marker of the seniority of the doctors whose cases are likely to be considered. So it's no surprise that the medical director, the most senior clinician, but also the line manager of clinicians within the organisation should be charged with this function, which of course is a critical function, because he or she is likely to decide whether or not a practitioner is exposed to a formal process which could lead not only to the loss of their employment, but have very significant career impact. And the jurisprudence of the Employment Tribunal reinforces again and again the importance of robust procedures where those sorts of interests are potentially at stake. And we say that that is a factor to be borne in mind as part of the relevant context. My learned friend says, well, can it really be envisaged that the Director of Human Resources couldn't deputise this role? Well, it is a marker of the robustness of these procedures and the seriousness with which these sorts of issues are viewed, that people occupying those senior roles are charged with specific responsibilities under this procedure. And I've made the point already in relation to the critical ingredient of clinical knowledge and experience. Doctors' performance is likely to be measured against professional codes of practice, good medical practice, some more specific codes bearing on the way in which clinicians are required to approach their work. Those are matters which the medical director will be familiar with. They are not matters which the director of finance, for example, or another senior manager might be familiar with. In other words, that experience is bound to be relevant and significant. So we say that the way in which this particular provision is drafted is clear, and to put the Lord Dyson test in place, could it be transposed into a contract of employment and have the characteristics of an enforceable contractual obligation? We say yes. There is no ambiguity, and it cannot sensibly be described as guidance or aspirational in flavour. The query that my Lord Justice Nugee raised about further stages, position is somewhat different, I think, to the way in which it was encapsulated, with great respect to my friend. If this is a conduct issue, it feeds into the trust disciplinary process, which is policy E5. If it is a capability concern, then it feeds into its own bespoke procedure under Part 4 of MHPS, or Section 4 of this procedure. And you will see Section 4 of this procedure at page 252 in the core bundle. And you'll see that that contains elaborate procedure arrangements through to a hearing. And it was this part of the procedure that the Chakrabarti case was particularly focused upon. And Mrs. Justice Simler had to consider where what's described in MHPS as the pre-hearing process had contractual effect, or whether or not it was in the nature of guidance. And that was a process which entailed consulting NCAS, PPA as they're now called, about issues of remediability before a trust could go forward to a capability hearing. There was conflicting authority on it. An earlier case called Lim and Wolverhampton said that NCAS effectively had a veto on the ability of the trust to move forward with its own process. Mrs. Justice Simler concluded that that would disturb the autonomy of the employer organisation, but it was a process of consultation that needed to be gone through in order to comply with the contractual requirement for a referral of NCAS before a capability hearing. So that was the particular matter of analysis in terms of whether or not the provisions had contractual impact that was considered in Chakrabarti. But the guidance provided in that case was important in our submission, because great emphasis was placed by Mrs. Justice Simler on the protection conferred by the provision. In other words, did it comprise some sort of valuable provision in terms of the doctor's perspective, or whether or not it was pure guidance, if you like, more of an administrative or aspirational character? And I'll come to that analysis, if I may, in a short while in a little more detail. Can I turn very briefly to the correspondence? And I do hear very much the court's remark, my lord's remark, about not wanting to delve unduly into the factual circumstances, but and I will bear that those cautionary words in mind. But if I can just go to the supplemental bundle and to page 14 in the first instance. This is an email from, I think, the Deputy Medical Director, writing to my client, marking out Miss Y as someone who would be incredibly helpful when there are any legal or reputational issues, and would be very supportive in creating a response if needed.
Sorry, whereabouts are you reading from?
That's just at the very top of page 14
I
in
see,
the
yes,
supplemental
yes,
bundle.
Yes.
This is soon after my client had made the disclosures that my learned friend Mr. Gorton has described.
Yes.
If we go to page 21, we can see that the role of that individual is crystallized on some further extent in an email of the 5th of September, this time from the Deputy Chief Executive, writing to colleagues. And just at the bottom of the next page, last bullet point, appoint Miss Y as overall lead for all aspects of the Letby inquiry and in overseeing any further investigations as required, seeking appropriate legal support for the trust as required. Now, of course, no reference there whatever to MHPS or indeed to any sort of process being applicable in this case. If we go to page 25, this is the first intimation of the institution of a process, so far as my client was aware. He was called into a meeting in circumstances he describes in his witness statement, without the benefit of representation, I add that as an aside, or a companion to be with him. And he had a discussion with Miss Y and Mr. Z and was presented with this letter, which makes reference to the planned statutory public inquiry in the 3rd paragraph, and says, we consider there are grounds for us to investigate the full facts surrounding your judgment, decision-making, and actions at that time. The next paragraph explains that the Trust's local MHPS policy will not be used, as these events do not involve matters of conduct or performance. However, the issues cause sufficient concern to warrant this investigation do go to the heart of your employment and contract with the Trust. Goes on to describe a fact-finding process of investigation. We will evaluate the findings and consider what action, if any, we should take. And then the next paragraph, I must inform you, if we conclude you've fallen short of the high standards we expect of our employees, there's a possibility that the subsequent process may result in your dismissal. Now, of course, I've already made the point that classification of concerns, still less any forward action going beyond the classification of those concerns under MHPS, is a staged process. And a critical phase of that is to investigate what those concerns consist of. it said in that the penultimate paragraph, as the concerns do not relate to your clinical practice, there's no risk to patient safety, therefore no need for exclusion. That said, exclusion may still be considered as a necessary option during the process. Now, that letter was responded to by concerns about procedure. Page 29, Miss Y responding to my client's then solicitor, referring to earlier letter, the trust and the inquiry specifically about what process is being followed, the trust not following any prescribed process, as this matter does not fall within the scope of MHPS. And then there's an assurance that a fair and transparent process would be followed. If we go forward to page 39 and a further communication from the trust, Ms. Y responds in the first paragraph, I continue to act and respond as the authorised officer of the trust in this matter, wants to bring matters to a reasonably swift and fair conclusion. There's an agreement to place one strand of the investigation on hold. That's the patient strand.
Sorry, I wasn't keeping up. Which page are you on?
Page 39, letter of the 15th of March.
Yes.
And midway down the page is a reference to the patient complaint. And there's an agreement at this juncture that that would abide the outcome of the Thirlwell inquiry.
Yes.
But other matters would proceed. And continuing over the page, again, there is an assertion that MHPS doesn't apply. We don't propose to enter into a detailed technical discussion concerning the legal interpretation of the E27 policy. Matters not one of conduct nor performance, therefore that procedure does not apply in this case. However, we acknowledge that MHPS contains certain prescribed procedural protections that in these circumstances we intend to apply and adhere to as part of a general obligation to which the trust commits to treat your client fairly. And this, of course, is reflected in the cross-appeal in terms of what that assertion amounted to and what applying the protections of MHPS truly consisted of.
The language is quite interesting because it might be said it's not the language of voluntarily offering to do something.
My lord, that's certainly the way we read it, is that there is a sense of gritted teeth here.
No, it's more my thinking that the word, there seems to be an appreciation that it's a matter of obligation.
Well, indeed, but an obligation that is only partially acknowledged in practice, because, of course, we have Miss Y retaining the reins in terms of what we regard as this critical ingredient of the case manager.
Yeah.
But we also have, and I'm going to cough, excuse me, we also have a statement of what happens next, in other words, the section 120 stage, where future action is going to be decided upon. My lords will recall that a variety of procedural routes is described: conduct, capability, referral to regulatory bodies, engagement with NCAS, etc. But a distinctly truncated range of options is offered at the foot of the page. That there is in fact nothing of concern, no further steps, that there are real concerns that go to the heart of the employment relationship. That would not relate to your client's conduct, but rather whether the essential term of trust and confidence has been irreparably damaged by the acts and omissions of your client. And that, of course, took us into a discussion about sidestepping what was being envisaged here, what trust and confidence, aside from the issues that had been delineated in the terms of reference, which were squarely about conduct in a clinical role, what trust and confidence meant. And we, on behalf of the doctor in this case, found that an unsettling reference. Then there is an assertion in relation to the case manager topic, top page 128. I will address the issue of whether the case manager must or indeed should act as the case manager as your letter demands. I'm afraid I disagree. Nowhere in MHPS, nor E27, not least 120, does it prescribe that the case manager must, the medical director must act as the case manager. And reference is made across to Byrne, and the fact I think that no point was taken in that case. But we consider we were bemused on behalf of the doctor in terms of that reading of the provision, which seemed to us to be unrealistic in terms of the explicit meaning of that provision. Further correspondence ensued that I think I can cut through, but we then get to what looks like a proposed way out of the knot that had been tied, page 46, 12th of April, Trust, again Miss Y writing on behalf of the Trust. Under MHPS, Roman 1, I'm reading almost to the bottom of the page, the medical director, page 46, my lord,
Thank you.
12th of April, medical director will assume the nominal role of case manager, but will, however, delegate responsibility for this to myself, which of course eloquently expresses the very issue that we were complaining about. And it seems a wholly artificial device to maintain the status quo, this notion of the medical director occupying some notional role or symbolic role, but de facto shifting all of the responsibilities across to Miss Y. And you've been referred to, my learned friend, to the email at page 48, which I don't need to recite. Then we go to a solicitor letter, page 77 in the bundle, from the Trust Solicitors, 5th of August. Again, further debate about the reference to trust and confidence in the passage that I've already referred you to, numbered paragraph 3 at the bottom of the page. Clear at the outset of its preliminary assessment of the situation, this was a matter in relation to which MHPS does not apply. Specifically, the matter were issued trust and confidence arising out of your client facilitating visits. A little bit further down, which has the potential to raise questions around implied duties such as trust and confidence and or give rise to reputational issues for our client. And one senses one's moving towards the kernel of all of this in that paragraph there. A reference is made to the Kerslake case, inaptly, as we say, because that case dealt with very different issues. But now that my friend's abandoned his points in relation to issue 5, I don't need to detain you further in relation to that. There's further discussion about the purported delegation of the case manager role by Miss Y, to Miss Y by Mr. Z. And this point, this is not a case where there's any need for a person with medical clinical background to act as case manager. And I've made my points already as to why that seems to deny the very procedural protection that we were concerned about. 3 final letters just to show to the court. The PPA advice, you've seen this in one form. I think it's the same letter at a slightly earlier point in the bundle, page 82. PPA record advice given via a Teams call to Miss Y and Mr. Z on the 31st of July. And the PPA advisor discusses the role of the medical director, how it's tackled in other trusts. Incidentally, we understand this gentleman was formerly attached to Morecambe Bay Trust, where you've seen the particular solution that was alighted upon. Top page 84, note that the trust, as a foundation trust, has the freedom to develop its own approach outside MHPS, subject to this being appropriately set out within an agreed policy and procedure. As such, you should ensure that any action that you take is congruent with the requirements of your local policy. In our submission, wise words, which were utterly ignored, because of course it was essential to have regard to that issue of congruence. You may wish to explore with the MPS, that's the professional association supporting my client, the precise reasons why they're objecting to you as case manager, so you can reasonably consider and take appropriate action, possibly an alternative case manager. And then there's a reference to encouraging organisations to explore problems and concerns first. Apropos that topic, and perhaps rather presciently, because this letter wasn't copied into my clients, page 86, we have my instructing solicitors writing to Miss Y and putting forward a proposal in open correspondence aimed at trying to find a basis of compromise, top of page 89, notwithstanding our client's contractual right without prejudice to his position, should the matter need to be litigated. In order to find a basis of compromise and to allow matters to progress, our client is willing to agree to Miss Y undertaking the role of case manager subject to two provisos, and those you can see, the second being the more apposite for present purposes. Any decision on future steps in the process following receipt of the case investigator's report shall be made by the medical director himself in accordance with MHPS Part 1, Paragraph 17. I stress that was without prejudice to our contractual position, and it was a proposal made a full year prior to the trial in this case, or close thereto. And at page 91, we have the response from my learned friends instructing solicitors on behalf of the trust, and in relation to this particular proposal, page 92, numbered paragraph 3b, as has been outlined in earlier correspondence, our client's medical directors delegated the case manager role to Miss Y. As such, she will undertake that role in its entirety. In other words, embracing that section 120 stage that we regard as critical. So that terse and, might one say, unyielding response is where attempts to try and find a via media hit the buttons. In terms of guidance on the issue of abstinence,
Meaning we can put the supplemental bundle away.
I agree. In terms of the guidance, again, it may be convenient to provide references rather than take your lordships to the authorities in detail, but of course I can do that if it's of assistance. But following the Alexander and Standard telephone case and citing its guidance, I think in every example that I'm going to refer to, the interpretation of provisions within MHPS or its local derivative have been considered on several occasions. I've alluded to the first of them already. That's the case of Hamid, which is in Divider 6, decision of Mrs. Justice Swift, Authorities Bundle, page 81. And at paragraph 68, at Appeal Bundle 82, Her Ladyship regarded a small minority of provisions within the framework as being too vague or too discursive to amount to an express requirement. So Her Ladyship was persuaded that in the great majority of cases, unless those limiting ingredients were in place, the framework should be regarded as contractual. Hussain approaches things somewhat differently, and as I say, with reference to a set of indicia that his lordship referred to and which have been picked up and used in subsequent authorities. I should say that Mr Justice Andrew Smith noted the approach in Hamid and set it alongside another case, the decision of Mr Simeon Mascry from recollection, deciding, I think Mr Mascry, QC as he then was, looked at a formula where matters should be applied unless there was a good reason not to do so. And Mr Justice Andrew Smith considered that the Hamid approach was preferable based on aptness, but he considered that it didn't actually matter which approach was applied in terms of resolving the issues that he was required to consider in that case. His Lordship at paragraph 168 considers useful guidelines, which he describes as non-exhaustive guidelines. He once again considers whether or not a provision has a advisory, hortatory, or an expression of aspiration, which might indicate that it wasn't properly viewed as contractual. But he offers the following indicia, the importance of the provision. And that, as I say, is echoed in Mrs. Justice Simler's judgment in Chakrabarti very strongly. And interestingly, his Lordship says that provisions important to implementing the agreement about exclusion in that case and about conduct hearings are also apt to be contractual. In other words, the mechanism surrounding a contractual requirement was also part and parcel of the obligation that his Lordship discerned in that case in relation to Part 2, in relation to exclusion provisions. The level of detail was a further consideration, the certainty of what the provision requires. The context of the provision, and his Lordship pointed to cases where other contractual provisions surround the material provision. And in relation to 1.6, we note a variety of musts in the language, that there are a variety of obligatory features of that part of the process. But we also say that the process as a whole, the appointment of the case manager, the tasks that he or she is set, the end point of their specific involvement under Part 1, the decision on future progress, those are all highly significant features of the procedure viewed in the round.
Can I ask you this? I'm sorry to interrupt you.
Of course.
Would one of the relevant indicia perhaps be to whom is the provision addressed? I think I may be misunderstanding. I think one of the submissions made by the appellant is that this is effectively a kind of address to the senior management team at the trust, and so it should really be regarded as a kind of internal governance document. Right? Is that a possible way of analysing a term to ask, is it intended to confer rights on individual employees?
I think
or is it addressed to the governing structure?
I think it is an entirely legitimate factor to weigh in the balance. In this case, we recall that the framework is described as an agreement, and these
Also 2.2, it says it's designed to,
confer rights.
yes, but it's designed to tell the staff what the policies are.
My Lord, with respect,
That, if I may say so, with respect, of course I understand that's the nature of the general document. But if you're looking at, and I think everyone agrees that you don't just incorporate the entire document, you have to look at the aptness for incorporation of an individual provision. I think what's said about 1.6, I'm not saying I agree with it, but I'm just wondering whether at least a relevant factor for the court to consider is to whom is a provision addressed.
my Lord, I would accept that that is part of the general interpretive task, is to understand what sort of provision one's looking at. Is this guidance to management? Or does it seem to confer a different sort of...
Well, there are two points embedded within that answer, if I may say so. One is to focus on the guidance part, but you may be right that it's not hortatory, it's more than advice, it's more than guidance.
Yes,
It might be said a provision has a flavour of obligation.
yes.
But there may be a subtly different question, which is, to whom is it addressed? In other words, is it intended to create individual rights? Or is it simply saying that as a matter of good governance, that's how you should behave?
My lord, I think one needs to engage with the provision as a whole, but also the individual components of the specific provision, which delineates a separateness of entitlement as between consultants and those at sub-consultant grades. It seems to describe a level of procedural protection that certain categories of clinician are entitled to enjoy. And we say that that has a more substantive character than being in the nature of guidance to management, which isn't likely to be read as conferring any sort of individual procedural right or protection.
Right, thank you.
In terms of workability, a great deal of evidence has been explored, both at trial and referenced in the course of this appeal hearing, to how burdensome it would be if the case manager had to discharge this sort of task rather than be able freely to delegate it to others. Well, those issues were considered by the trial judge. He evaluated them. He considered what in reality the burden of the task comprised, and of course noted that a good deal of the day-to-day operation is down to the case investigator, but there are some critical points of decision-making which fall to the case manager. And therefore, there was a degree of skepticism about the way in which the burden was portrayed in evidence. And so was the learned judge skeptical about the rather apocalyptic description of disastrous consequences that would flow from an application of this provision. And the learned judge, I think, was right to reject emphatically that suggestion. Anecdotally, the cases that I've already referred to are cases where the case manager discharges this role. I appreciate that's not a representative sample, but it is illustrative of the fact that in complex cases, and Chakrabarti certainly ticked that box, the medical director discharged this function. We have the evidence from the PPA advisor who talked about the statistical picture. But the great gap in his analysis was how many of the trusts out with the 46% or whatever it was that did utilize the services of the case manager, medical director as case manager, how many of them had gone down what one might describe as the Morecambe Bay path of formulating their own procedures to accommodate the approach that they were adopting. And that, of course, brings very much to mind the self-same witness's advice letter that I showed the court a short while ago, where he said, look to your own procedure to see whether or not the way in which you're proposing to act is congruent with that procedure. So we simply do not know whether or not there is any deviation or departure from the established procedures of trusts, because we don't know whether or not and to what extent they've modified their local policies in the manner that Morecambe Bay illustrates. And of course, it's possible that in a given case, the trust could openly and cooperatively come to the doctor and his professional representatives and say, would it be all right? We appreciate the strict letter of the process, but we have in mind that the deputy medical director would be a suitably trained person to undertake this task. Are you comfortable with that? But as you've seen from the tenor of the correspondence, a year before trial in this case, that wasn't quite the spirit in which matters were discussed. So looking at that in element of the indicia of workability, And I think if one looks at the guidance on, and I have Arnold in Britain with Lord Justice Nugee's cautionary words in mind, but if one looks at the guidance in that case, it's questionable whether that sort of evidence is admissible as an interpretive aid at all. But it is there in the indicia that the learned judge in Hussain, Andrew Smith J, provided. He didn't see any magic in the differentiation between must and should. In other words, my lords may have seen he didn't detect some clear, consistent thread in the utilization of that language. But we're not in that territory here. We are in the territory of a juxtaposition between mandatory language against permissive language in the relevant clause.
Well, you say mandatory language, it's actually in one sense, it's predictive language. To say will doesn't necessarily have the implication of obligation. But what I think the basic point you make is the stark contrast between will and may in other cases.
My lord, with respect, I agree. And I think that is why I'm able to put forward the point as emphatically as I do. His lordship comes, and I'm referring to Mr. Justice Andrew Smith, does emphasise the importance of looking at what the wording of the language provides. Perhaps rather surprising, at paragraph 169, his lordship observes the wording of the provision is also of significance. If one put that in front of Lord Justice Underhill in Byrne, I wonder if his lordship would say it's highly significant, perhaps primarily significant in terms of the exercise of interpretation. But in any event, it is given proper weight in the analysis that that judge applied. And once again, at paragraph 172, I consider, forgive me if I don't take my lords to the judgment itself, but I can quote from it. I'd also consider the requirement for exclusion be limited to 4 weeks at a time to be contractual between Dr. Hussain and the Trust. It's an important part of the arrangements for exclusion designed to provide protection. So once again, the point I've made in relation to the mechanism that gives effect to contractual or to procedural protections, attracting contractual status. Chakrabarti is the case that considers part 4 of the framework, and the issue of aptness is addressed by her ladyship at paragraph 110 in the judgment, Authorities Bundle, page 299. And again, we stress the emphasis that is placed on the importance in terms of conferring a valuable protection on the employee as part of those procedures. And similar points arise, albeit in a different employment context. In the Sparks case, Lord Justice McComb there, deriving assistance not only from Hussain, but also from this court's approach in the Keeley case in 2006, to which reference has already been made. I've already addressed the issue of the extent to which this court can be assisted by evidence of what other trusts do, or the wider picture. I don't need, I think, to revisit those points. I've taken them slightly out of sequence in my note, but I've made the points that I think I wish to in relation to those matters. Can I turn to the learned judge's findings in relation to aptness, which are addressed at judgment paragraph 103 onwards, core bundle page 68. And the learned judge at paragraph 106 takes note of the guidelines in the Hussain case and essentially works through them, and in our respectful submission provides a cogent and compelling analysis of why those indicia point to the conclusion of express contractual incorporation and effect in the interpretation of the relevant clause in this case. The importance of the provision is addressed paragraph 107, citing Malone, rejecting the notion that I've described as apocalyptic of disastrous consequences, looking at the issue of the workload bearing on the case manager, not involving equivalent day-to-day burden viewed alongside of that of the case investigator, noting rightly, and I shouldn't give evidence here, but rightly in practice, that the medical director case manager will receive some administrative support and assistance, either through HR or through lawyers, often solicitors providing assistance in drafting letters and so forth. But pointing out, so long as the medical director makes the decisions and carries out the specific actions required of the case manager, and I've addressed that also.
Sorry, where are you reading from there?
My lord, I hope that paragraph 107, I've
It is.
brought that across into my note, I'm afraid.
It goes on to say that it only applies to investigation clinical leaders and not the far more numerous junior medical staff. Was there any evidence as to the split of
I'm not convinced there was, my lord. I think that may have been
judicial notice?
judicial notice. I don't think we had
Some
specific.
judges are able to take notice of things that others don't.
Yes, my lord, I can't say whether the learned judge in this case has any particular medical insight, but I don't believe there was specific evidence bearing on that. Paragraph 111, further reason for why paragraph 16 referenced the medical director having to act as case manager is apt for incorporation is the language used is suitable for contractual incorporation, and I think there's a nod in the direction of Keeley there as well.
That's Keeley, isn't it?
Yeah. And then 112, reflecting furthermore some significance in the wording reflecting MHPS, reflecting the importance of the requirement that the medical director should serve as case manager of case involving and so forth. And of course, it's relevant to look across to the corresponding provisions of MHPS, where one again finds an equivalent provision and indeed a slight elaboration of that in terms of where a trust doesn't have a medical director, and there's a double asterisk which I ought to just pick up in terms of what should happen in that situation. And my lord, I wonder if you just bear with me a moment while I find that reference.
Page 154.
I'm very grateful. 154, and just a third of the way down, embodies that do not have a medical director. Chief executive should designate a senior clinical manager to perform the role assigned to the medical director in these procedures and ensure that they are appropriately trained. And we say that that is a valuable pointer where one has a situation where there is some insuperable obstacle in terms of the medical director being able to perform this role, whether because of conflict or because of illness or some disenabling or disabling event. That is a pointer to the characteristics of the substitute appointee. My learned friend has made reference to the way in which the exclusion provisions of the framework are formulated. And the learned judge in our submission was right to describe those as a specific set of circumstances which do not apply in all cases of an investigation of a consultant. And we believe that that is a realistic analysis of what is happening in section 2 and its corresponding provisions of MHPS. Structurally, it is a somewhat self-contained set of procedures. It doesn't walk in step with the other procedures of MHPS or its local derivative. It has, if you will, a procedural life of its own. Exclusion can take place where no disciplinary process has been invoked. It is contained within itself, and it describes a series of trigger events and justifications which may entitle the trust to exclude an individual. And it is heavily caveated with the requirement for it to be interim and to the most limited extent necessary, it can apply to a range of circumstances that have no disciplinary stamp or flavour to them. Take, for example, the bottom of page 243, 216. There's been a serious breakdown in relationships between a colleague and the rest of the team. Or indeed, on a more extreme level, 219, formal exclusion, one or more clinicians, concerns about serious dysfunctions in the operation of a clinical service. So it deals with its own set of criteria which may trigger a justification for the imposition of an exclusion or restriction on practice. As I say, with a very heavy emphasis on keeping matters restricted to the minimum. We looked at the delegation provision at 214, and can I pick up my Lord Justice Singh's observation about the very specific delegation provision that is provided there? The suggestion I think Mr. Gorton was making is somehow that makes a nonsense of the separate provisions in relation to delegation under Part 1. But we take the reverse point, which is this very clearly delineated carve-out, separate from the arrangements under Part 1, shows that a distinct approach is being adopted in relation to powers of exclusion. And I think the trial judge below noted the very much heavier administrative burden that arises under these procedures, which involves preparation of preliminary report, reporting to the trust board, ongoing and routine reporting during the currency of an exclusion. There is a very different character of burden and commitment arising out of the operation of these procedures, which provides a rationale for a separate approach being adopted.
If you have an exclusion and you delegate to case manager,
Yes.
the case manager makes a decision, but does it need the imprimatur of medical director?
That is my reading of 213.
That's what I thought.
Yes. It's not crystal clear, and I would accept that. But that seems to be a very specific authority position. The chief executive exercises that power in relation, no doubt, to a vanishingly rare circumstance of a medical director being excluded. But otherwise, the medical director is required to exercise that decision-making power. But I agree it's not entirely clear as one traces it through that part of the procedures. The issue of sidestepping has gone away, and that, I think, takes me to the respondent's notice. And
I'm not sure I have entirely understood what the issue of sidestepping was. Is that the trust and confidence?
The trust and confidence point.
Trust and confidence not being conduct.
Exactly. In other words, there is an abundance, a superabundance of case law dealing with this issue of the extent to which concerns about relationship breakdown, dysfunction, caught within the MHPS framework, and the clear view has emerged that those issues aren't part of the MHPS issues of conduct or capability. They are freestanding. They may require their own procedural approach. We would say they certainly would do, but not as part of the MHPS procedure. And therefore, the idea of transmogrifying concerns that are purportedly about conduct into something about breakdown in relationships is something that the case law has said no to. Mr Justice Linden in the Smo case, which is a Welsh case actually with an entirely different set of procedures, unhelpfully still modelled on HC 99, which is a Byzantine process that my friend described earlier, which led to all sorts of delays and complexities. That's live and kicking in Wales, and that led to the procedural snarl-up that occurred in the Smo case. Can I turn to the respondent's notice, and in the 10 minutes or so that I have left, just to set out our position on that, and I think it can be shortly stated. My lords have seen the references in the correspondence to the trust indicating that they would follow MHPS and doing so in distinct terms so far as the investigation phase is concerned. So that qualification was offered, but we will follow MHPS. And as you've seen in the March letter, doing so in a distinctly partial and selective way. And the issue that we raised, and I do emphasize that we place our primary case in the express incorporation and aptness basket, but as our secondary position, we say that this does raise an issue of the extent to which a fairness obligation arises, which may or may not be a facet of the trust and confidence duty. My Lord and Lord Justice Singh has expressed some cautionary words about seeing a duty of fairness as a byproduct or as a linked concept to trust and confidence, because it enters into the choppy waters of the employment tribunal's jurisdiction and the extent to which there may be some conflict in terms of the fairness obligation or the fairness, statutory obligation of fairness, and a contractual duty that might be seen to, and this has obviously been explored in a range of very high-level authority about these difficulties. But the notion of an obligation of fairness does seem to be developing into a distinctly recognised procedural duty in the context of disciplinary procedures. Lady Justice Simler noted in Chakrabarti a duty of trust and confidence and then a duty of fairness, but expressing it in terms of a narrower duty of fairness in the context of disciplinary procedures. My Lord Justice Singh, and I think his views endorsed by Lord Justice Underhill in Byrne, really saying that that was perhaps a short further step to take in recognising this existence of such a duty. And in Chabra, we have Lord Hodge, who provided the judgment in that case, acknowledging a duty of fairness in the context of disciplinary procedures.
It might be thought in principle that's the most important judgment, because that's the Supreme Court.
Of course.
In Byrne, what I said was undoubtedly obiter,
Yes.
Although the other two members of the court did agree with my judgment.
Yes.
But in Chabra, is it part of the ratio, or?
I think it is, and let me just turn up the reference in Lord Hodge's judgment, which I think the best course is to take you to it. It's at tab 11 in the authorities bundle. And I think the fairness comment or finding appears at the very foot of page 327 in the bundle, at the end of paragraph 37, I'm so sorry, para 37, page 329. And his lordship's there is evaluating various types of procedural breach and whether they would individually or collectively have justified an injunction in that case. And then dropping down to the foot, it was also contrary to paragraph 3.1 of the policy D4, as it was behaviour which the objective observer would not consider reasonable. Dr. Chabra had an implied contractual right to a fair process, and Dr. Wishart's involvement, and Dr. Wishart in that case was an HR advisor who wrote up the severity of some of the findings in an in-case investigator's report to give them greater accent and impact. And so there is a finding, and I think it is part of the body of the judgment rather than expressed obiter. And that seems to be an authoritative recognition of that duty. Was it a duty that was engaged in the circumstances that I've described? Well, the learned judge was unconvinced on that point and expressed his view at paragraphs 119 and 120 of the judgment. Page 73 of the core bundle. And his lordship explained that he didn't need to resolve this issue because he dealt with the matter on another basis, found that it was contractual term and so forth, questioned whether or not the same result arises pursuant to the duty of trust and confidence does not arise. As the matter is fully argued, however, I will deal with the matter briefly. In my judgment, it would not have been a breach of the duty of trust and confidence for the trust to state that it would be adhering to the procedure set out in MHPS, but make an exception for the identity of the case manager. On the assumption the procedures set out in MHPS that relate to the identity of the case manager are not incorporated into the consultant's contract of employment, there's no reason why the trust could not decide to derogate from some of the procedures set in MHPS, even if others were followed. The touchstone for what the trust could do is that of fairness. There's no reason in principle why it would be unfair for the trust to appoint someone other than the chief medical officer as case manager for the investigation. That other person could have been a senior member of staff such as Miss Y. Well, we consider this notion of fairness in a way requires some sort of bolting down. Is it a purely subjective sense, or are there some ways in which it can perhaps be more clearly delineated in the way that the duty of trust and confidence is, which has its own quite specific formulation, not to act without reasonable and proper cause in a way that is calculated or likely to undermine trust and confidence. There are clear components there to the way in which this duty might be analysed and applied. How is that to be applied in this sort of situation where a trust says, we will apply MHPS, but then doesn't do so in ways that the employee regards as highly material? Well, there is some case law, and I'm afraid it doesn't quite resolve the matter, and it is limited, and it's a case decided
Just
again.
before you go to the case, if the trust had said unequivocally from the outset, no, we're not applying MHPS, that on this thesis would be fair?
I don't accept that that would be fair. Of course, our primary position is that they were bound as a matter of express contract to do so. But we say that we had a entitlement for those procedures to be applied. They were clearly devised in order to support and provide protection to doctors. So I think an outright refusal from the outset to give effect to those procedures couldn't be described as fair. Can I take the court, and this is the only authority I'll refer to on this point, and I think the last point that I wish to make before handing over to my learned friend is the case of Jane, and it's a decision of Mr Justice Swift, and it appears at tab 17, and it involves a complex set of facts which I don't think I need to burden the court with, because the particular point with which the court was concerned was a situation where there was a policy very similar to the MHPS policy we're concerned with in this case, but the JNC had never ratified it, so it had effectively sat on the back burner and no one had applied their minds to it, so it hadn't been adopted in the processes of the trust. Paragraph 35, in response to a submission on behalf of the trust, whom I represented in that case, however, except that on the facts of the claimant's case, it's correct to conclude that the provisions of MHPS are relevant considerations when determining whether the trust has acted consistently with the trust and confidence obligation. This was essentially the submission made by myself, who appeared on behalf of the trust, even though the MHPS had not been incorporated, either expressly or on the basis of custom and practice. The letter of the claimant solicitor sent on the 2nd of November 2015 and the further letter of the 5th of November both made it clear that concerns raised relating his competence in professional relationships would be addressed under MHPS Part 4. Having taken the decision to address those concerns by that procedure, My conclusion is that the obligation to maintain trust and confidence required the trust to follow the procedure set out in MHPS unless there was justifiable reason not to do so. So a degree of fleshing out of how that sort of implied term might be approached. Of course, one can't place weight on analogous facts. We're in a different set of circumstances here. But there is a clear sense that the learned judge considered that if a trust says we are going to adopt this course, we are going to apply this set of procedures, then they should do so. And we suggest that the trial judge's view in this case that there was, if you like, some latitude to derogate from that position at the instance and exclusively at the instance of the trust is a difficult finding and one that we would respectfully invite this court to revisit.
And I know you're running out of time. Would that be an evaluative decision by the judge such that we couldn't interfere absent unreasonableness or the like?
We would suggest that in this case the court can make its assessment of what fairness requires and entails in the given circumstance.
You may derive some assistance from the public law context,
Yes.
where the Supreme Court has held that what fairness requires, procedural fairness requires, is a question of law.
I'm grateful.
I'm not sure that it's going to help you
No,
in this context. So, before you finish, Mr. Sutton, may I just ask you this, to see the analytical framework of your case. If you succeed on your primary argument,
Yes.
which is based on contractual force of 1.6,
yes.
do you need any of this?
I suspect not.
Right.
And
if
so
you
we do.
All right. If you lose on your primary
Yes.
case and it doesn't have contractual force,
Yes.
then you submit to you that you can still win on this point.
We do. And so we offer this as an alternative but secondary position.
And what do you say in a sentence? What do you say about the objection that's taken against you, that it's not a respondent's notice point, it's a cross appeal? And I think it's also said that you never argued this, so it's never been adjudicated.
I think I tentatively agree with the first point and strongly disagree with the second point. My Lord, unless I can assist you further, I will hand over to my colleague.
Thank you very much. Mr. Begin.
Oh, thank you so much. Leave that with you. Thank you, my lords. In respect of costs, our position in summary is that the court did not, in awarding the claimant his costs in full. The trial judge has a wide discretion in respect of the award of costs, and there is no basis in this case for interfering with the exercise of that discretion. My lords, if I may, I would like to make 3 brief points on the law in this area and then 5 broad submissions, hopefully all within 10 minutes. I'm very conscious that you very much will know the law in this area. Nonetheless, just to remind you, and I don't know if you want to go to it or if you're happy for me just to give you the references, but I'm going to just take you to some points that appear in the 3 costs cases that you have in volume 2 of your bundle. And those 3 cost cases start at page 549. So sorry, this is not really working. So sorry, it was tilting. So the first of those cases is the case of Fleming and Chief Constable of Sussex. That appears at cost tab 1, Authorities Bundle 550. And the passage that I would like, if I may, to at least refer you to, whether or not you do want to go to that, is paragraph 32, which appears at page 562 of the authorities bundle, and it's that well-known guidance at 32 that one shouldn't interfere with the discretion of a judge unless you are satisfied that the judge erred in principle, took into account matters which should have been left out of account matters which should have been taken into account, or reached a conclusion which is so plainly wrong that it can be described as perverse. And I refer to that as part of my first point on the law, which is the limited scope of the appellate court's jurisdiction to interfere with costs decision. And as part of that preliminary submission, I also refer you to the bottom of that same paragraph 32 in Fleming. It's the last few lines. This court made clear that the Court of Appeal must exercise self-restraint in substituting its views for the views of the judge who has the feel of the case he has tried, as well as knowledge of its progress and nuances or detail which are not suitable for investigation on an appeal concerning costs. Similar points are made in the next case, and this is still on my first point about the limited scope for interference. In Castor Navigation, that's at tab 2 and starts at 567, but I would like to take you to paragraph 148 of that. And again, that is a reminder, and it says in terms, we remind ourselves, this is Authorities Bundle 579, paragraph 148, we remind ourselves that the rules confer a wide discretion on trial judges on questions of costs, and this court must exercise restraint. And again, it goes on to make the point that the question is very much not whether or not the appellate court would have made the same order. And just for your note, but I don't propose to take you there, the third costs authority, Terra Corp Mystery, tab 3, Authorities Bundle 583, makes similar points at paragraph 85, and that's Authorities Bundle that's Authorities Bundle pages 589 to 590. And that, of course, is reflected in the CPR itself, with CPR 44.2 paragraph 1 stating in terms the court has discretion as to A, whether costs are payable by the party, B, the amount of those costs, and C, when they are to be paid. And that, of course, emphasises the nature of the discretion that Castor also refers to. My second point on costs is that the starting point in an order of costs is that there is an award in favour of the successful party. And again, that is reflected in CPR 44.2 itself, as you'll be very aware. The general rule is that the unsuccessful party will be ordered to pay the cost of the successful party, but the court may make a different order. And just as a reminder, whether or not the court should make a different order, or, for example, an issues-based order, or whether it should go with who is the successful party, that itself is part of the court's discretion. And if I could refer you to two passages in Fleming, there's the last few lines of paragraph 35, where it's stated, nonetheless, the starting point is still an order for costs in favour of the successful party. More generally, the successful party is the party who has really won a trial by establishing the essentials of his case and his rights to a particular remedy. And it says later on, 5 lines from the bottom, this time paragraph 36 of page 563, but it still leaves as essentially a matter of the discretion of the judge whether to apply the general rule or make an issues-based order. And my third point taken from the case law you have before you is that the fact that one has not won on every point does not mean that there should be a reduction in the costs awarded to that party. And I don't think you need to go there, but for your note, That's at Authorities Bundle 587, paragraph 12, 1. So it's paragraph 12 and then Roman numeral 1, which is part of an overall paragraph 79, at Authorities Bundle 587. And it says in terms, there is no automatic rule requiring reduction of a successful party's costs if he loses on one or more issues. And then it quotes the late Simon Brown. The court can properly have regard to the properly have regard.
I think
I'll
given the
move on.
time, you probably better leave that.
Thank you. So my 5 points are, first of all, the claimant was clearly the successful party. In this case, I don't need you to take you there, but that is reflected in the order of Mr.
Don't worry about that.
Secondly, we say the claimant did, and perhaps this is the most important bit, we're very clear that the claimant did not abandon parts of his claim, and I can take you through that very briefly. If you have in front of you the list, I don't know if you've got two separate files, but if you have the supplemental bundle at 336 of the list of issues, and then the pleaded case, the particulars of claim, paragraph 5, paragraph 82, page 110. So just by way of reminder, those 5 issues were broadly 1, incorporation, 2, act for incorporation, 3, meaning, 4, A and B, alternative case, and 5, what I'm going to call categorisation or sidestepping. When you look at those 5, we say that each of the paragraphs, save for 82F, is encompassed in those 5 lists of issues. So A, sought to commission and continue an investigation into concerns without confirming the application of E27, which of course in itself applies MHPS. That's issues 1 and 5, incorporation and sidestepping. B, C and D all relate to appointing someone who wasn't the medical director as case manager and then impermissibly letting them take steps in that role, which they shouldn't have done. And those, of course, can all be dealt with by, and are dealt with by issues 1 to 3. And of course, if we weren't successful on that, then they are in the alternative dealt with by 4A. 82E is issue 4B, Muswise participation in the Thirlwell inquiry. Well, that was only a secondary argument, and if the Trust had been with us on our primary arguments, we would never have to have gone there. And then G is covered again, we say, by issues 1 and 5, incorporation and sidestepping. And then H, we say, is covered by issues 1 and 3. Again, it's who's taking on that role, and in the alternative 4A. The only exception to that is F, and that is because of the confirmation given to the court by Mr A that he would take appropriate advice if required. We weren't looking backwards in our application. You will see that it was always the case that we sought pragmatically an injunction on a forward-looking basis. We weren't asking for the investigation to be reopened. You can see that at 111. And I say again, the declaration sought reflected the issues in the case. More fundamentally, perhaps, in our submission, the fact that the parties have managed to distill the key issues into an agreed list of issues is something that should be encouraged as facilitating an easier trial and not something that should be penalised in costs. Moreover, to the extent there were any matters that were considered not pursued, the judge, of course, this is my point 3, did take them into account. My learned friends referred that to you. He says, well, he didn't have any cost budgets in front of him. Well, I say to that, it doesn't matter. The point is, he's the trial judge. He's got all the documents in front of them. He can see how much various issues have taken up time in the bundles and in the witness statements. And he's better placed than anyone else to judge realistically how much time things should take. And frankly, a cost schedule isn't going to break it down that much anyway. And the idea that a trial judge would be expected to, in effect, carry out a detailed assessment in my submission is not proportionate. My 4th point, finally, is that the conduct of the parties is also relevant. We, as you'll see from our skeleton, and I won't take you through it, but you will see, and our skeleton refers to this at paragraph 69, that you will see that we made various suggestions about an ADR or a practical way forward, and we even made a without prejudice offer that you have in the bundle, supplemental bundle 328 to 329, and you heard Mr Sutton refer to a different pragmatic way forward where someone else would make the decision at the end. And we say, again, this is relevant to conduct. We were trying for a long time to see if a pragmatic way forward could be reached, and it was not. Finally, we say there's no basis for going behind the orders of Mr Justice Garner and Johnson. They very much made orders that were costs in the case. Had it been appropriate for costs to be reserved, that could have been dealt with at the time. It wasn't. My lords, unless there's anything else I can assist you with.
No, that's very helpful. Thank you very much.
My lord.
Mr Gorton.
I can just deal with 4 points, if I may. I'm not going to deal with anything in relation to costs. And they will be the issue of 1.6 referring to governance. I'll deal with the respondent's notice stroke crossing. And in that I'll also deal with Shabra, and then I'll deal very briefly with 2.14 in relation to what my defender said. In respect of governance, which was the point that my Lord Justice Singh was putting to my learned friend, can I just take your lordship to, or take the court to precisely that was one of our points. So if we go to page 66
Of
the core bundle of the judgment, and paragraph 87, and holding that with the skeleton argument, which I'll take your lordships to in a moment. In relation to aptness, amongst other things, and this doesn't reflect everything that we said, in relation to paragraph 6, the provision doesn't regulate the employer-employee relationship, but is an internal facing matter relating to the conduct of trust. Precisely what we said. It's precisely what we say in paragraph 25 to 27 of our skeleton argument. Can I just take the court to that? In other words, this isn't regulating the important issue between the parties. This is dealing with the internal governance of the trust. So I pick that up at paragraph 25 of our skeleton argument. That's the internal part. And 26, we say it does not seek to prescribe bilateral obligations between the doctor and the trust. So that's the first point. That was at the front and centre of our case, that what 1.6 meant. Can I deal with my learned friend's respondent's notice point and his emphatic repudiation that this wasn't the case that was put? Well, it's not in the pleading. That, in other words, if I understand it correctly, that the letter of the 15th of March establishes that we would follow the procedure, and the letter of the 5th by way of a general obligation of fairness. If I can just take the court to supplemental bundle, and I think my Lord Justice Newey now is part of the crowd. You have this 336. As I say, there was a bit of choppiness in relation to the production of the list of issues between the parties, but that was eventually gotten over. And if your lordships look at page 337, paragraph 4, which is that if you decide that the issues in relation to 1.6 incorporation and meaning, and by meaning I also mean appellants, if you're against the claimant on that, the doctor on that, then at paragraph 4 is the wide, broad suggestion that by appointing Miss Y as the case manager and delegating that role to her, that is a breach of the implied term of trust and confidence. So that's not an argument, and that wasn't a case, and it wasn't pleaded on the basis that you've taken on that obligation by way of saying that you will apply your policy under E27. And of course I can go back to it, but she says expressly, my learned friend took you to it, she says expressly in that letter, I am and I remain properly delegated to act as the case manager. So she's not doing anything there other than confirming what her view of the policy was. But in any event, it's in my respectful submission, greatest respect to my learned friend, it's an entirely circular argument. It goes like this. Okay, I lose on the contract point. 1.6 isn't incorporated and or 1.6 doesn't mean what it says. But I can rewrite the contract through the implied term of fairness in order for it to say what I want it to say. That, with respect, makes no sense. And related to that is the case of Shabra, where I think, if I understood the learner friend correctly, he was suggesting that that established to a degree some jurisprudential guidance in relation to fairness. I don't accept that. If we go to page 315, which is where the judgment is at tab 11, and if we go to the key finding of Lord Hodge, that starts at paragraph 34. And if I can just take the court to that, paragraph 34 is, as it were, an assembling of related points which breaches the contract of employment. And the first one, which one would have thought is the only one you need, is that the doctor was charged with an allegation of gross misconduct, and that was not made out on the facts. So that would be curtains anyway to any process. And the rest are, as it were, cumulative, supportive matters which go to that conclusion. It does not establish a general duty of fairness.
It doesn't seem, but I'll be corrected if I'm wrong, to have been fully argued. It might be thought, given how much controversy there has been in employment law on this issue, it might be thought that it would be fully argued and recorded as having been fully argued.
Yes. But we've got one of the advocates here who argued it. And in fairness to my learned friend, he wasn't terribly enthusiastic about pushing the point that that's what it decided. He thought, after some thought, that it was. And we say it doesn't. It wasn't a case about a general duty of fairness. It was a case about a breach of the implied term of trust and confidence by virtue of what the employer did and didn't do. And principally, the employer promised to keep X from the process, and X was deeply involved in the process, and that was a breach in itself. But more importantly, as I've already said, if you've got a charge of gross misconduct, which isn't made out on the established test, and the established test normally is whether all the facts being accepted, this could possibly give rise to a finding of gross misconduct. That would be the death knell for that case in any event. By way of proceeding, you'd be entitled to an injunction for it. You can't proceed to a hearing on the basis of a gross misconduct charge if, in fact, you don't have the basis in which to proceed.
I understand all that, but in a case in which a judge says there are 4 reasons which cumulatively lead me to conclude that X, are each of those reasons part of the ratio, or what is the position?
Well, is it a ratio in the sense that it's just as it were, an application of the legal test? It's almost a finding of fact. It's a slightly unusual judgment, Shabra, in the Supreme Court, because you're not dealing in the end with precise hard-edged issues of law. What you're dealing with is what an accepted issue of law, whether that is what that amounts to. And I suspect that's largely informed by the Court of Appeals being the Court of Appeals decision, which was effectively, we just don't think you should have been involved in interfering with this case. And that's why, to a degree, you've got this in Lord Hodge's judgment or reasons, which says, well, you were.
Standing back from Chabra, do I understand you to submit that it's not implicit when you run a disciplinary process, or you have to do it fairly?
Oh, the trust in this case has never tried to disassociate itself from their obligation of fairness. That is acceptable. Whether that amounts to a breach is an entirely different matter, I say. Yes, we're a responsible public body.
As I read the judge's reasoning at paragraph 120, he says the touchstone is fairness, which appears to suggest that actually, at least implicitly, he was accepting that there is some kind of obligation of procedural fairness, but he found it not to be breached. And as I understand his reasoning, it was that you can't just, as it were, transplant all the requirements of MHPS stroke E27. If you've lost the contractual argument, you don't just, you said earlier, you don't just bring it in by the back door under the rubric of fairness. And that would be, if I may say so, consistent with how the courts tend to approach these sorts of problems in public law, where the ultimate guardian of procedural fairness is the court. That's why it's a question of law. But what fairness requires is very dependent on context. And so you can't just say, well, because somebody has said that we will follow a certain procedure, that is inherently required by a judicially enforceable obligation of procedural fairness. So there is a minimum flaw. So if, for example, a decision maker was biased, was taking bribes, the court will interfere.
Yes.
But it doesn't follow that all the panoply of procedural safeguards, like having a panel, like having 3 people on it, and all the rest of it, which may be in some express procedure, you can't just say, well, all of that now comes in through the implied procedural duty of fairness. I think that's what the judge is probably getting at.
For once, I'm not disagreeing with him.
No.
I'm not disagreeing with him.
No,
Your Lordship's observations in Byrne arose to a degree out of, if I understand it correctly, rose to a degree out of the fact that they tried to argue that but didn't get permission from Lord Justice Bean. And your Lordship did that.
Yes,
Yeah, they didn't get permission on that.
Yes.
But I said, certainly from a practitioner's point of view, if you're going to run an argument about general fairness, you need to have the facts, you need to have the pleadings, you need to have the case, and you need to have the judgment. What you can't do is spin off from this case that argument. I say, well, it wasn't argued in that way, it isn't argued in that way, and it can't be sustained in that way. And can I just finally deal with 2.14, because I listened very carefully to what the learned friend said about 2.14. We fundamentally disagree about 2.14 on a very simple basis, that by reference to 2 matters. First of all, our speaking note, which hasn't been challenged as being either inaccurate or wrong. First of all, in relation to our speaking note, and second, in relation to the inception of these policies. The idea that the two don't sit together is, with respect to my learned friend, nonsense, because they do. And you get a very simple explanation of that through our analysis under exclusion before a case manager is appointed. And I would just invite the court to read that careful analysis, which is what you've got, as I said a little bit earlier in my oral submissions, what you often get is you get a flashpoint where something happens, and the issue then is, what do you do at the medics? Take the most extreme example, physical assault on a patient. What do you do with the medic at that stage? Well, you don't have a chance to appoint a case investigator. You don't have an opportunity in which to do a preliminary report. But what you do have is a very serious allegation, which is wholly incompatible with the doctor's duties. And if the doctor remains in post, that could give rise to all sorts of problems. So at that flashpoint, you get the right to exclude immediately, so long as you then follow certain procedural safeguards. And we set all this out in our speaking note under paragraph 7. What you then get, and these procedures sometimes are not entirely compatible, but what you then get is the next stage, which is that you get a review of what's happened, you get a case manager appointed if they're not already there, and you may get a case investigator appointed if they're not already there. And away you go. They have to assess whether their exclusion can continue. But there is no difference between those individuals, the case investigator and the case manager, in the exclusion process than it is in part 2 than they are in part 1. They must be read together, and they should. Those are my submissions.
That's very helpful and timely. Thank you very much for your very helpful submissions on both sides. We're not going to give judgment here and now. You'll get it in the normal way, and at that stage, we'd be grateful if you'd seek to correct our English and typing. It won't, of course, be an opportunity to re-argue the case. At the same stage, we'd be grateful if you would seek to agree an order dealing with consequential matters. If there are any points on which you can't agree, can we have brief written submissions? And we would expect to settle those points in the order that we make. Finally, although I'm sure this is very well known to everybody here, I ought to stress the importance attached to the embargo. If you think of anybody who ought to see the draft judgment who we don't already know about, you obviously need to come back to us. But thank you all for your very helpful submissions.
Court rise if able.